I think there are a few ways to do it, and I think it's a dangerous thing the prosecution is doing in this case by using this murderer's row of informants to try to prove its case. Because what the defense is going to do is say, wait a minute, this happened in 1998, and the experts at the time, especially Chambliss, was uncertain as to what happened here. And we have this guy living his life, getting married, having children, raising his children, otherwise being an upstanding member of the community, and then all of a sudden he goes in jail and starts bellowing through a megaphone to all these informants, hey, I'm guilty, I did it. Makes no sense. And what they're going to do is they're going to say, you cannot trust Dillard. If you wouldn't trust him alone with your children, if you wouldn't trust him alone in your house for 5 minutes, if you wouldn't trust him alone with your wallet for 5 minutes, you can't use his word to convict my client. And what they're going to do is, here's where it's dangerous to the prosecution. What they're going to do is, and I've done this before, is walk over behind the prosecution's table and say, Mr. Dillard, and you expect this state, this prosecution team, to come to court when you're about to be sentenced and tell them what a good person you are. And it really kind of spills his pollution and his poison over onto the prosecution. I think it is a fundamental rule that either lawyer, prosecutor or defense lawyer, must be seen as the truth giver, as the person with credibility. It has to be unflinching. So when a jury looks to a prosecutor or a defense lawyer, as long as they're constantly being told the truth, when questions arise, if they look to that lawyer, and that's often the side game that's going on, as this is the person that's always been straight with me, this is the person that's always, what he has said he has delivered on, then yes, they will go. They will take that lawyer's hand. If it's the prosecutor, they will take the prosecutor's hand and take leaps of faith with them. When it comes to jailhouse informants, though, it's an enormous problem, Jack, an enormous problem. Remember the 10th Circuit Court of Appeals in Denver 5 or 6 years ago just threw out all snitch testimony resulting in convictions. The United States Supreme Court came in and overturned that to make sure. It's an enormous problem because these guys know, even if there isn't a written letter, their lawyers are telling them, help out on this case, and let me tell you, it's going to help you out in your case later on. What is doing here, and doing a good job of it, is showing to the jury that there's a lot of psychological technique that goes into these interviews. It's not just a detective going up to the guy and saying, by the way, tell us what you know about this, writing it down, saying thank you. It's long, it's pervasive. If you look at the video, they've actually got him backed into a corner, and what they're doing is doing that. And what the defense is also saying, it's not a fair fight here. This is a skilled investigator who comports himself one way in an interrogation room, another way in front of a jury. What hurts it, though, is that the jury is actually seeing him, and they're seeing how big he was, and they're seeing the dynamic of what happened there. But what the defense will say is, it's kind of like a Stockholm Syndrome type thing. After a while, you kind of want to please your interrogator, and the use of ruse, decoy, disguise, and deception, as is sanctioned and encouraged by the courts, really can elicit a false confession, a false testimony. Well, whether a client testifies or not is really one of the most difficult and sensitive decisions that can be made in any defense of any case. And it's an ongoing organic decision-making process. Sometimes at the beginning, you know this guy's going to testify, and sometimes you know he's absolutely not going to testify. You take a lot of things into account. Prior record is a big thing. Does the guy have a long record that he can be tagged with? If he does,
he's got no record.
He doesn't have a record.
Yep.
Well, no, this has all the ingredients for this guy to testify. He's clean cut, no record, and what's got to be, the decision has to be made here is, what the defense has done is thinking, look, this guy's already said everything. They heard that long interview that was videotaped, so everything he's got to say, he's just going to say again. On the other hand, they're losing the benefit of him turning to the jury, maybe a little mournfully, and say, look, I didn't do this. I'm innocent of doing this. That's a very powerful thing, and you got to hope that they follow the law.